and ask your questions away. We will be addressing them. If we don't address it right in the moment, at the end of tonight's presentation, we will try to hit every question that you guys ask. So let's get started. So Reggie is a 15-year-old sophomore at Delaware High School, a public school in Milwaukee. Reggie was first identified as needing educational supports in the first grade. He has been diagnosed with ADHD, disruptive mood dysregulation disorder, PTSD, and anxiety. Because of his diagnoses, Reggie has been identified as a student with a disability and qualifies for an IEP. His IEP has, among other things, an accommodation that says that if he's feeling overwhelmed or agitated, he can give his teacher a secret signal and be permitted to take a brief cool-down period outside of the classroom. Mr. Murphy is one of the math teachers at Delaware High School. Mr. Murphy is a retired Marine and has a reputation of being tough and running his classroom with military-style strictness. He is not sensitive to disability issues and makes no effort to read or otherwise be familiar with his students' IEP. Mr. Murphy is Reggie's Algebra 2 teacher. Reggie finds math very challenging. One day in class, while working through some math problems, Reggie becomes increasingly agitated and he's having trouble focusing. He begins tapping his pencil loudly. Mr. Murphy doesn't like this and asks Reggie to stop. This only further agitates Reggie. Reggie rolls his eyes and sighs, which Mr. Murphy finds disrespectful, so he shoots Reggie a disapproving glare and says, "I asked you to be quiet, Reggie. I'm not going to ask again." At this point, Reggie is embarrassed and feels like he's going to lose his temper, so he begins giving Mr. Murphy the secret signal by pulling on his ear. Mr. Murphy sees this but ignores him on purpose and continues with the algebra lesson. Reggie strains to get Mr. Murphy's attention, still giving the secret signal. Mr. Murphy continues to ignore him. Reaching his breaking point, Reggie shouts, "Excuse me, Mr. Murphy." Mr. Murphy responds, "No, you're disrupting my class, young man. You will remain seated and silent until the lesson is finished, like everyone else." Reggie flips out, tossing his papers and pencil, overturning his desk, and running out the classroom. So that's section one. So now we have some questions for our panelists. I will start with Lauren. However, if anyone else on the panel wants to contribute, by all means, contribute. So question one, Lauren, can you explain to us what an IEP is?
Absolutely. So IEP is an acronym that stands for Individualized Education Program. It is a document that outlines the different special accommodations or services that a child with a disability gets in their public school. These documents are used throughout public schools, which includes charter schools in Delaware, but they are also governed by federal law, which means that other states in the United States also have IEPs, and that term is used nationally. But it's basically a document that outlines all the different services that that child needs in order to make progress in school. And the different supports are geared towards helping that child's disability-related needs. So it's different for every child depending on what their unique disability is and what their unique learning needs are.
And how often are these IEPs reviewed and modified by schools?
So IEPs are governed by a federal law called the IDEA, and that law requires them to be reviewed at least once a year, and that's the bare minimum. But families can actually request to have the IEP reviewed more frequently than that and ask to have a meeting about it. But at a bare minimum, the school is required to meet annually and review the document.
And what role do parents and students play in developing an IEP?
So they play a very important role. They are a member of what's called the Iep Team. And that team also includes teachers that work with the child, people who have special education degrees like school psychologists or educational diagnosticians, but also any different special related service providers working with the child, like if they have a counselor at school, a speech therapist, an occupational therapist, a behaviorist. But the parent and the child have an equal voice on that team, just like every other participant, and their feelings about what accommodations and supports the child needs to make progress are meant to carry just as much weight as everyone else's in discussing how to develop that document.
So going off of that, if a parent believes that a child needs additional supports in school or that they're interested in getting an IEP for their student or for their child, what steps should they take?
So the most important thing they should do is send a request in writing. Something that we see often in our current criminal, cases with kids, but I saw a ton also in my education cases when I was in private practice, is parents call the school or they call the teacher that they know the best and they make the request verbally. And the danger in doing that is that if it happens verbally, there's no way to prove when it happened. And it's super important to be able to prove when it happened because that triggers some very specific timelines under the law for the school to actually develop that IEP. So a parent or a guardian should submit either an email or they could write it on a piece of paper and take it to the school office and ask the school to make a copy for them to keep and then to deliver that to the child's special education administrator in the building. But every member of the school staff is governed by the IDEA and has a duty to take a request and forward it to the appropriate channels when that request is made. So I always tell parents, reach out to the teacher you have the closest relationship with, or if it's the school counselor, send them a request in writing that says, hey, I think my child might need an IEP. I'd like them to be evaluated. And it's even more helpful if you can specifically say why, because you want to give the school notice of the reasons why you think your child might be eligible for special services. So you could say, he's really struggling with math, or he's getting suspended all the time, or he's struggling to pay attention when he is in class. Give them the specific issues that you're seeing as a parent so that can help them decide what areas they might need to evaluate and address in the IEP.
And so in the fact pattern, we saw that Mr. Murphy wasn't paying attention to Reggie's secret signal and that he doesn't really pay attention to any of his students that have disabilities and IEPs. What obligations does Mr. Murphy have as it relates to Reggie and his IEP?
So Mr. Murphy and every single staff member in the school building are governed by a duty called child find. That duty is basically the federal rule that says if you think a child within your classroom might qualify for an IEP, you have to offer them services, and you also have to implement the services that we have determined they're eligible for. So if you have an IEP, you've got to follow it, you've got to implement it properly, you've got to read it, you've got to know what's in it. So Mr. Murphy is obligated to have read Reggie's IEP. He's obligated to follow whatever services are outlined in it. So he's supposed to know that Reggie has that secret signal, and he's supposed to be prepared to give Reggie his approved breaks and cool downs when Reggie tugs on his ear.
So if a student or a parent finds himself in a situation like Reggie and the teacher or the school in general is not following the IEP, what steps should they take?
So they should absolutely put something in writing to the school, alerting the school to the issue. Depending on how serious the situation has gotten, they might want to consult with an attorney. There is also a nonprofit entity in Delaware called the Parent Information Center, which is the state's designated office that provides education information to parents about what their child's rights are, what steps they can take if they're in a situation like this. So they could also reach out to PIC, Parent Information Center, and ask PIC for help and guidance in this situation. But at a minimum, I would say send an email, either to the principal or to whatever administrator the parent feels they have the best relationship with, alerting them to what happened in Mr. Murphy's class and saying, I obviously expect that my child's IEP is going to be followed, and I'd like to have a meeting about this. I'd like to know what the school is going to do to address and remediate this situation.
Great. My last question for part one, and I'll open this up to everyone so Lauren's not on the hot seat alone. What, if anything, should have Reggie done differently after he found himself getting frustrated and being ignored by Mr. Murphy?
So legally, it's not Reggie's duty to properly implement his own IEP. I mean, I think he, could have tried to engage in some calming coping strategies rather than escalating to the level that he did. But the reality is that he's a child, and we expect the adults in the classroom who have the proper credentials and degrees behind their names to know how to help him, because some of his issues are issues that are beyond his control. He has PTSD, he has mental health diagnoses, and he just may not be in a position to regulate himself, especially in an environment that he already finds really stressful and triggering for him. He could have potentially reminded the teacher, this is an accommodation and can I please take a break? But he's not required to do that.
And I just want to turn this to Detective King real quick, just for your quick perspective as an SRO. I know you may not necessarily need to know all the ins and outs of an IEP, but when you have a student-teacher conflict, what are kind of your role and your expectations? What would you like to see the students do in these kinds of situations?
Well, one thing I would like to emphasize is that the school resource officer is a resource. So oftentimes kids actually walk out of class and come to my office. And I keep that open. And the reason why we in Delaware try to keep SROs in certain schools for a certain amount of time is because we develop certain relationships. So I have certain relationships with kids that I can talk to, and I can talk them down, or I can get through to them. I can de-escalate. I can also try to develop a relationship with kids that are in that situation where I can talk my way out of it, where the teacher and the child is safe, because my concern is safety, where no kid or child gets hurt.
Thank you. Does anyone else want to add anything before we move on?
I'm just curious, and obviously you couldn't prepare for everything in the scenario, but one question would be how many students were in the class, and two, what would the teacher do when the student goes out, even if he gave the signal and let a young gentleman out in the hall without any supervision, or should he stop instruction? Where's the meeting point? I guess I would ask from Defender Services, what would you argue that the teacher should have done? Because there are 20 some other kids in that classroom. So what do you do?
So those are great questions. And I think, the school is the one that writes the IEP. So they should write an IEP that they feel they can safely and realistically implement. And if they don't feel they can safely and realistically implement it, then they may need to look at potentially moving him to a smaller setting, moving him to a special school, moving him to an emotional support program. So if he's the kind of kid that has such high needs that they can't be properly addressed in a regular education setting with a large number of students, then that's, incumbent on the school to say, we need to move him to a smaller setting where we can make sure he and our staff are going to be safe and able to learn. But usually when this kind of support is in an IEP, it's not like the kid is just given a blank check to wander the hall. It's usually an approved break to go to sit in the guidance office, or go to a preferred staff member that is the child's kind of trusted, cool down staff member that they get a chance to take a break with.
By the way, I had difficulty with Algebra 2 as well, and I didn't have an IEP. I was extremely frustrated. That's why I hate math to this day.
Well, it sounds like one of the buzzwords that was used was the child fine obligation, which may have not been exercised with fidelity with your honor to identify that you may have been a student who may have been someone who could have benefited from some additional services. And that leads me into two sort of areas that I wanted to explore with this group, which is leans into the idea of what should schools be doing, and more importantly, why aren't they doing it? I think, you know, it's a safe assumption to say that a school wants to provide the most enriching learning environment for the students that it serves. It does not want to purposefully not provide a student with all of the resources that it can in order to be successful. However, we wouldn't be having this discussion if that standard didn't fall short, and the law wouldn't need to be created if there wasn't a need to make sure that folks knew there was a standard. So I'd love to explore, you know, with anyone who'd like to comment on it, what their perspective is about the barriers to schools being able to exercise the child find responsibility with fidelity, and then to be able to deliver on the IEPs as they're written with fidelity. Because you could have a plan, but you still got to implement the plan, right? As the case with our student, Reggie, he had a plan, but the plan wasn't necessarily implemented. So curious to hear what folks may have seen in the field, or just what your perspective may be on it.
I'll try not to talk too much. Oh, go ahead, Nicole.
Just a small note on this. So I have several colleagues and close friends who work as educators, some in administration, some in the classroom. And just talking with them about students, particularly students that maybe have IEPs or other forms of supports, it seems like, based on their experience and their feedback, that it can sometimes be overwhelming. It's a lot to keep up with. IEPs are catered and specialized to each individual student. And so being under an obligation to know what each IEP is for each student, if you have multiple classes, or maybe you're in one classroom and still have multiple students to keep tabs on, can be a burden, particularly in the public school setting, where there's also maybe some lack of resources and supports for the educators. And so that does not minimize the obligation that they have. They still do have the obligation to know and to respond appropriately when incidents happen, but it can be burdensome. It's, at least that's the take I get from them.
And I think Detective King, were you going to add something to that as well?
Yes, I was going to echo with my colleague just said that, because I talked to various staff members, and they often shared that frustration of the obligation of helping one child, but if helping one child is a hindrance to 22 others, where do you draw that line?
And that sort of dovetails back to, I think, the comment that Judge Tolliver was making, sort of leading into this, or suggesting that you're making decisions on the fly, and the real context for it of teaching. The law doesn't change. The law is clear what it requires, but there is certainly some dynamics that make delivering on that obligation under the law challenging. And certainly during this COVID experience, I'm sure that has been heightened even more for educators, because their obligations have not changed. The IDA did not change for COVID. It did not change for the remote learning environment. So it still had to be delivered with fidelity. And would love to hear some feedback and comments. Looks like Judge Tolliver was about to say something about that.
I speak from several perspectives. One, my father, 3 of his sisters, and one of my first cousins all taught in the public schools, 3 of the 5 in Delaware. 2 I had children, have children, but they're grown, who were in the public schools. And 3, I had responsibility for juveniles charged with adult and juvenile crimes in the Superior Court. And what you find is, I understand what Wali said about the law being the law, but the law must be interpreted in a real sense. I've got teachers. If Detective King said 22 other students, that was probably a small class. Then what do you do with the other kids, some of whom may or may not have issues, while you're trying to teach a tough, or not, maybe not even not a tough situation? And you also have to be concerned with the safety of those other students. And I know as a parent, I had an administrator tell me that we had to protect the due process rights of the student who was threatening my child. And I explained to him what negligence was and what an obligation they had to protect my child, who wasn't the subject of an IEP. If they had them back then, I guess they did. But there are so many factors that while the law doesn't change, I think its application has to be somewhat elastic. And here you have a teacher who wasn't sensitive to this to disability issues. Probably the law was concerned with teaching his subject, and then you get a kid who has some issues. My question is, should the kid have been in that class in the first instance? And then you run against, do you segregate kids with a problem like that, or do you put them in with other kids that they could learn from? I do not know the answer. I just know it's a complicated, complex scenario. And then you have the law says what you must do. And I'm not so sure the law is always realistically formulated by those who have to deal with it.
I would love to add to that, both to Judge Tolliver's comment and to Ali's comment. The IDA and COVID was and continues to be a very challenging thing. I know Wali mentioned that when COVID hit, those obligations did not go away. I would actually take it one step further and said those obligations heightened. It became more challenging. I was in the governor's office when COVID hit, and when we closed schools came running to us, Department of Education came running, trying to figure out, well, how do we stay compliant with our obligations under the IDEA? How do we make sure students with IEPs are still getting the supports they need when we're going to be doing this remote virtual setting, and all these other unknown factors that were going to be kind of like a trial and error. It was a very, very stressful time for educators, for administrators, and education lawyers trying to navigate this world and make sure that students of all backgrounds, of all supports, still had the resources that they needed. And I would say, quite honestly, there probably were some shortcomings of that, given the novelty of the situation, but COVID definitely exacerbated some of those disparities.
I wanted to go back to one thing that Judge Tolliver mentioned, the idea of, do we segregate kids with disabilities? Is it a better thing to have a student like Reggie in a classroom like this, or is it better to remove him altogether? The way that IDEA is formulated, it has what's called a least restrictive environment standard, which basically says that when they decide, the IEP team sits down and decides, okay, where should Reggie be? What supports should he get? How are we going to address his PTSD and ADHD and his other mental health diagnoses? They are required to decide what is the least restrictive educational setting we can place him in that is going to allow him to learn appropriately and safely. And it's a continuum of placements, with the one end of the continuum being full-time in the regular education classroom with typical peers who don't have any disabilities, big classrooms with regular, teachers and no co-teachers. The opposite end of the continuum is we remove him altogether and place him in a separate special school or even a residential school in pretty severe cases. But then there's also a continuum of placements in the middle that kind of offer increasing levels of support. So all the staff members from the IEP team are supposed to sit down and look at the evaluations on Reggie and decide where can he be properly served in that continuum. But the goal is to try to keep him with typical peers to the greatest extent that that can be, appropriately and safely achieved. But I will say also, I do agree with everybody on this call. My husband's a teacher. My sister's a teacher. My godmother's a teacher. My grandfather was a special education teacher at Del Castle. Teachers are underpaid and they do way more than they should ever have to do in their jobs. And IDEA is a funded law, meaning that the schools get money from the federal government and from the state to fund their ability to implement IEPs properly, but it's underfunded. It doesn't get nearly the amount of money that it should get for them to be able to, really implement services to the best level, which is why it only requires them to implement services to an appropriate level. And so that's what lawyers fight about. How much was Reggie being appropriately educated as opposed to whether he was getting the best education he could possibly get.
Lauren, you mentioned something, and I think the viewers would. You mentioned the IEP team. Now, we working in the school, I pretty much know what an IEP team is, but I think everybody would benefit from learning, like, who sits on the IEP team.
So there's certain participants who are required. There has to be at least one teacher that works with the child, and it could be any classroom teacher. There has to be at least one administrator with the authority to commit resources. So oftentimes that's someone like the educational diagnostician. They have to have someone with the right credentials to interpret evaluations. So usually there will be like a school psychologist present. But if there's other types of evaluations on the child, like if the child has speech language needs and they've had a speech language evaluation, or they have psychiatric needs or whatever, they have to have the right people with the right degrees to interpret those evaluations and provide input. They have to have the child and the child's parent or guardian. And then the child and the parent are actually entitled to invite anyone that they want to join in IEP meetings. So they could bring an advocate, they could bring a friend that they trust. They could bring, a lawyer. But, I think that's intended to help families feel like they're not overwhelmed by the perspectives of all the different professionals at the table, and that they can bring their own people to the table too. But those are the required participants.
All right. It looks like the chat is heating up. So I wanted to hit some of the questions from our viewers. So first question is from Camille, and she asks regarding IEPs, does this include college students as well?
So the answer to that is no. IDEA only applies from birth to when a child turns 21. Most colleges are private to begin with, but they do not get funding to implement IEPs. The law that does apply at the college level is Section 504. So if a child has a 504 plan, a 504 accommodation plan, that can carry over at the college level. That's an anti-discrimination law, and it's a completely different type of civil rights law. And so those do apply in colleges.
Thanks, Lauren. Sandra asks, in what cases would a teacher call an SRO on a student?
Can I ask that? Can I maybe ask that in two parts? I'm sure you could probably say they could call them on any and for any reason, but what maybe is an appropriate best practice for use of an SRO? Because I'm sure you've probably seen SROs being called for any number of things. And don't let me put words in your mouth, but I suspect that's the case. But I just wanted to put that modifier on there, and maybe you could answer that.
Yes, sir. Well, The SRO shouldn't be called for any school administrative issues. Some states are different, but in the state of Delaware, I have, as an SRO, no administrative power. If I'm walking in the hallway and I see a kid cutting class, I can do nothing. So the SRO should not be used in that capacity. So the only time SRO should be called if there is a legal matter of safety or an illegal matter, period, that has to deal with the student or staff member. But once again, the SRO should not be called for administrative issues.
Do you find that some people fall short of that standard?
Yes. Yes. And it's twofold because being in the building, you are an asset, you are a resource, and like, not to toot my own horn, but I'm good at what I do, and I have great relationships with kids. And so they might call me because they know, Detective King talks to this guy every day. We might talk about sports or, things like that. So they might call me in that function where I have a rapport with a kid. But like, if, for example, if let's say someone is being removed from a classroom and is refusing to leave, and if they call me, my first question is, has the kid been suspended? Because if he hasn't been suspended, then he has nothing. He's not committing a crime. He's just violating school policy. Now, if he has been suspended and still refuses to leave, then we're dealing with a trespassing issue.
That's what we call in the law a distinction with a difference. As I see some heads nodding. Paige, do you want to take a few more questions, or did you want to? Okay, I'll defer to you on that.
Yeah, it's only one more question and then 2 comments if you guys want me to read the comments. But the last question is from Jaylyn. She asked, would it help for schools to have students with IEPs meet in groups to talk to each other and encourage one another? And I'll leave that for the whole group to answer.
So I'm a little rusty on this, but I'm sure Nicole or Lauren or even you, Paige, might be able to or even Detective King. Is there a privacy element to the IEP plan process that, and I see the heads nodding. So, and I'm not sure if that is something that the student themselves can opt out of. And I see the head nodding. So I want to defer to Lauren because I see her head nodding. She knows about this stuff. So
it's on a need to know basis. So anybody that needs to know about the IEP in order to implement it is allowed to know about it. So any staff member that's going to be charged with, working with that child in the classroom and implementing the services has to know. But beyond that, it's not supposed to be shared, and schools are bound by FERPA, which, protects students' privacy rights. But kids could opt in to a group like that. So, for example, we have lots of students with autism in Delaware public schools who participate in social skills groups where they meet with other students with IEPs and they work on social language skills and perspective taking. And so in that capacity, they opt into participating in a group with other kids with IEPs. But I think it's possible for schools to, to craft any kind of a group. Like if they felt like kids would benefit from participating in like a group, counseling group or a buddy group or whatever, they can absolutely create that kind of thing. And then the kids would just be allowed to opt into it as part of their IEP supports.
All right, and we just have 2 comments, one from Michelle, and she says, perhaps a child who needs this level of support should have the IEP that provides an additional teacher in the class working with students who have IEPs. And I believe Lauren touched on that a little bit earlier, and that it's a spectrum of services and supports. So there are situations in which there will be
Can I briefly make a comment about that too, which I think is important to say, is that that's definitely a solution that could and should be implemented, but there's also the elephant in the room is this resource allocation issue, and all schools are not equally resourced in their ability to bring in specialists, to have, we talked about the members of the Iep team and who should be ideally part of. We talked about maybe a reading specialist and a school psychologist on site, and maybe having some of they call them paras, but it stands for paraprofessional. That would be an individual who would help provide support in the classroom to a teacher. But every school district doesn't have the same resources. Schools are funded differently. I know Lauren mentioned earlier that there is funding that comes with you're honoring your obligations under the IDEA, but it's an underfunded mandate. So I think that's part of this conversation as well, is the fact that there is certainly solutions, but then the question is, what are the barriers to those solutions? And there are some real issues with some resources within all schools. You might see some schools that are doing or performing their obligations at a very high level. And again, I think part of it's an awareness and a training issue, but then there's also, I think, a resource issue. And I would invite colleagues on the panel to maybe see if they agree or disagree with that assessment.
I 100% agree. My husband taught at the now defunct Prestige Academy Charter School. And when he was teaching there, he's a history teacher. He was also serving as making breakfast, driving kids home, taking care of after school stuff. And it's just a lot more than what, he's now asked to do in his current school. So there's absolutely a disparity in resources from one school to the next. And it shouldn't be that way. One interesting thing I observed when I was practicing in my private education practice, I had cases in Pennsylvania and I had cases in Delaware. Pennsylvania does something that I think is really smart, and that sometimes I think is a big picture solution Delaware should be looking into. They have what's called intermediate units, and these are kind of local buildings that are shared by multiple surrounding schools, and they offer certain special services that it's just not feasible to have at every individual school building. And so kids get bused to the intermediate unit either certain days of the week or for half their school day or whatever to receive those more specialized services that the state just doesn't have either the staffing or the funding to put in every individual building. And I think that's a smart way to do things more efficiently. And it seems to work really well in Pennsylvania. They overall do a better job with IEPs, in my experience, than we do here in Delaware, unfortunately. But they also have a lot more litigation around IEPs than we do in Delaware. But I think that's interesting that they do it that way. And I kind of wish we would jump on that bandwagon.
Wali, I guess my reaction would be somewhat historical. Delaware used to have, around the time of DSEG and the combination of one large district in Newcastle County and the 4 areas, what were called ILCs. And I think that stood for Intensive Learning Centers. And the attendance might have been varied, as Lauren said. And you can have the paras, as you indicated, but I've also been involved in litigation where there was difficulty in the para doing the paraprofessional's job given the conduct of the kid. And so you have many factors, and you talk about funding, and I understand funding because I've lived here all my life, school funding. But the thing I would say to you, and the litigation that was resolved, I believe, by voluntary settlement, school districts, the state accords so many dollars per unit, student unit, which you can use for any number of reasons, but local school districts are entitled to raise local taxes to supplement that. That was a problem when you had the segregated school systems, because the local districts, the special school districts, and I know what that is because I attended one and my father taught at another one, did not have the local tax base that might have been necessary to help. Now, what the answer is, I don't know, but it's not as simple as saying put more money into it and the problems will stop. Because it's been tried a number of ways, and we keep trying and trying to get it right, but let's not fool ourselves. This is a very difficult subject area, and I don't know where Lauren's area of practice in Pennsylvania, but if it was across the line in the northern part of the section, you're also dealing with more affluent districts too.
That is true. I will say the two exceptions to the Pennsylvania being the better of the two states with education on the special ed side is Philadelphia school district is really struggling, but I had cases statewide in PA, and they in general, I will say one thing they do that we are, I think, gradually getting better at here is they really do very thorough evaluations of kids when they first enter with an IEP. And I think the key to having a great IEP is having a really good evaluation, because, the goal of IEPs is to kind of follow the medical model. So like, just like if you went to a doctor with a broken bone, the doctor isn't just going to sit there going like, well, what can I do? How can I fix this? Let's think about things. They're going to run tests. Like they're going to do x-rays. They're going to do an assessment. They're going to look at you physically. And once they get all their data, they're going to prescribe a treatment plan. And that's how an IEP is supposed to work. So it's supposed to be great evaluations are done first. We look at the data in them and we come up with our treatment plan. And then if the treatment plan isn't working, we modify it as we go. And Pennsylvania does a really good job of doing very thorough evaluations out the gate. And that, I think, leads to good outcomes for kids. And I think that's something we're getting better at here.
Can I throw a monkey wrench into the conversation a bit before we, and I know we have to get to the other skits / fact pattern scenario, but there's a part of this conversation that I think is very important to this audience, which is the overclassification of Black and brown children as having disabilities. And, it's sort of two sides of a coin, right? We're sort of talking about the side of not identifying children properly so that they can get the benefit of services. But then there has been this part of the public discourse about the overclassification of children, identifying them as a child with a disability, when really there should have been some type of intervention along the multi-tiered support, metric that may have allowed for a different outcome in their behavior as opposed to classifying them as X. And I'm wondering if we can maybe explore that part of the conversation a little bit in terms of how parents, the parent piece, maybe you have a child that could be benefited from engaging in the IEP process, but you may have a stigma about having your child be identified as a child with this disability. Curious to hear thoughts and reactions to sort of that dynamic.
Well, I'll make a few comments here on that. So overclassification is something that you do see more disproportionately happening to Black and brown students in schools. It's an issue that I actually have been investigating and looking into in my job here in Delaware, locally with our schools. As far as parents, I can't emphasize enough the point that Lauren made earlier about when you're communicating with schools, it's great to have a verbal conversation, but put your concerns in writing. Be able to have a paper trail of what it is that you're concerned about, how instances of treatment or judgment, preconceived notions that you feel that maybe educators or other people in the schools may have towards your particular child or towards you, and why that may be. And that's how you start to, that type of information, that type of tangible documentation would be helpful when it comes to pattern and practice investigations, which is something that certain offices, particularly in the civil rights realm, will be able to do to determine if there is a pattern and practice of some type of civil rights violation, a pattern and practice of discrimination, of unfair, illegal treatment, geared towards particular groups that have a commonality, a shared characteristic of some sort. So that would be my biggest suggestion is, yes, it's great to have those conversations, but make sure you have a paper trail that accompanies that, so that if there is a need to do further investigation, we can start to pick up on patterns and practices that may exist within particular school districts or departments.
I hate to be the bad guy, Mr. Rushdan, but you're saying on one hand, the mandate is underfunded. And then you say on the other hand, but you're making it too inclusive. Now, I would hate to be the administrator, educator in the middle of that conundrum, for one. Two, I agree that whatever you do, there should be documentation. But I don't know how you account for relative degrees of sophistication and familiarity with the educational system. And I go back to my own experience with my second child, who, shall we say, was no angel, but was pretty smart. And I had to go to the school on several occasions to talk to her teachers, who one of whom told me they didn't think they had to do certain things to help my child. I knew enough, having represented the Wilmington School District and done some work, that, and I explained to them, either you're going to give me what I want, or I'm going to get a hearing before the Director of Secondary Education and then the school board if necessary. But my concern after that meeting was, suppose a child's parents don't have a law degree, don't have a certain level of sophistication or interaction, then what we're saying is you have to hold the district accountable, and here's how you do it. And the question is how. So you have a lot of factors which are involved in the process of trying to get help for your child, but then determine whether your child is unfairly being pushed into an area and then not given help. And I'm not sure how well we're able to ferret out the various needs, but there are differing competing interests. And I'm not sure how you deal with it. And I'd like to hear from Lauren what she thought, or anybody else for that matter.
I agree with Your Honor on this. I'm going to push
That's
back
scary.
a little. I'm going to push back a little on the idea that we're over identifying, Black and brown students with disabilities, mainly because, and I believe you that there is data to support that that's happening. I guess my pushback on that is that when they are identified as a student with a disability and given an IEP, they get expanded civil rights that a typical student would not get. So from my perspective and on the advocacy side, working with students, if I can get a kid an IEP, I absolutely want to. They get more protection against being expelled, more protection against being suspended. They get, due process rights that a student without an IEP doesn't get. So I absolutely agree with what Wali said about there being a stigma around, identifying your child as a child with a disability. But what I always tell my clients is, this is giving you protection that is going to, give you more rights. And that's always something I want and that I think we all should want for our kids, especially if the child actually does have a qualifying disability. And I think we have to rethink what we think of as a disability. I think a lot of people think IEPs are just for kids who have traditional learning disabilities or who are intellectually disabled or have cognitive delays. And you could be an absolutely rock star, brilliant kid and qualify for an IEP. For example, if you have mental health issues and you need accommodations for your emotional and behavioral needs in order to function and be appropriately educated, or kids with autism who, they can have a 120 IQ. They could be the smartest kid in the class, but autism affects your ability to understand appropriate social interaction, and they may need their IEP for that kind of thing. So, IEPs serve a broad range of needs. And I always tell clients, if you can get one, you should get one. And I also have found, at least in my practice, and maybe Paige can speak to this too, when I was in both private practice and now, the vast majority of the kids I see coming through my door who should have an IEP and don't, and are being treated like you're just a bad kid, are Black kids. I mean, it's disturbing. And I think the ACLU actually filed a class action suit in Delaware about the fact that schools were disproportionately disciplining Black and brown students in situations where those students actually had qualifying disabilities and should have had IEPs and should have been getting services, as opposed to being just treated like a bad kid, shipped to an alternative school and getting suspended or expelled.
Oh, let me add, I didn't say anything about disproportionate classification. That was Mr. Rushdan. I simply acknowledge that the argument exists and that people, it's a two-edged sword, and I'm not sure how you address it. And the other gorilla in the room is the schools have a kid, I think I figured it out one time, like 25% of a week, and maybe a little less. So try as they might, be well-intended as they may or may not be, you also have a factor of how much can I do in the limited period of time that I have them, and given the due process rights you alluded to, with or without an IEP. So there are a number of complex factors involved in that, and there's no right or wrong. And I don't know what the proportion is. I've heard the same arguments about the mistreatment, but then that also goes to how do you establish that, and what is the level of parental involvement to advocate for the child and to say, give my child some help. Those are also factors which not often discussed.
I completely agree with you. And I will say that that's the sad reality, that many of the cases where the ball is dropped by the schools and the kid is not properly served for years and years and years, the saddest cases that I ever had in my private practice were those families who lacked that sophistication to realize that they were, being steamrolled and that their child had rights that were being violated. And, sadly, a lot of time passed before finally a well-meaning teacher, and many of the strongest cases I had were teachers who pulled a family aside and said, you got to call a lawyer. Like, I don't have enough cachet myself to fight this fight for you. But you got to call a lawyer and get some help. And it's sad that it should ever have to come to that. The duty of child find is on the school and the school alone. The law recognizes that parents come from varying backgrounds. They don't have the educational savvy or the degrees to always know, oh, my child's issues are coming from a disability and I should be asking for services. So the law puts that burden on the school and on those, those staff members that do have the education and the expertise to reach out to the kids and to the parents and say, hey, we think your child might need services and we'd like to evaluate them. And here's a permission slip. Can we do that? But it doesn't always happen that way. And, it's often the families that lack the savvy that unfortunately have the saddest cases. So the squeaky wheel gets the oil. And I always tell parents to graciously but firmly push the ball forward, advocate for their child, but try to do it in a way that maintains good relationships. Because at the end of the day, everybody's got to play together in that school setting, usually for many years. And to the extent that you can avoid burning bridges, you should do that. The lawyers should be the emergency room. They should be the last resort.
All right, this was Great. This is really exciting. There are two other questions and comments, one from Herb and one from Armani. I'm going to save that for the second half because I think it kind of relates more to the second half of this fact pattern where things get a bit juicy with Reggie. So let's check back in. So where we first left off, Reggie has overturned his desk and his pencils and he stormed out of the classroom. So Mr. Murphy calls down to the front office for administrators and the school resource officer to come apprehend Reggie. Officer Smith finds Reggie pacing up and down the hallway, fist balled and chest puffed out. It's obvious that Reggie is still upset from his interaction with Mr. Murphy. As Officer Smith approaches Reggie, he immediately grabs Reggie by the shoulder and says, "Come with me, young man." Reggie pulls away from Officer Smith and tries to walk away. Officer Smith shouts, "Stop walking away and come to me to the office." Reggie responds, "No, I'm not going anywhere with you. I hate this place." Officer Smith catches up to Reggie, tells him that he's now under arrest and to stop walking away. Reggie continues walking and tells Officer Smith no. Officer Smith then catches up to Reggie and aggressively grabs him by the shoulder. He then attempts to handcuff Reggie. However, Reggie keeps his arm stiff, making it difficult for the officer to properly cuff him. Officer Smith repeatedly shouts, "Stop resisting! Stop resisting!" He then does a maneuver which forces Reggie to the ground, and he's finally able to put cuffs on him. Reggie is charged with disorderly conduct and criminal mischief for damaging the classroom door and resisting arrest. This was not the first incident Officer Smith has used force against a student. It is not uncommon for him to get physically aggressive with students. In the past, students and parents have complained to administrators at the office and district office that Officer Smith is too physically aggressive towards the Black and Latinx students. However, he's not physical at all towards the white students. As a result of the takedown maneuver Officer Smith did on Reggie, Reggie suffered bruising, and his family has noticed a drastic change in Reggie's mood. He's now hypervigilant, paranoid, and noticeably depressed. His family would like to file a criminal and civil action against the school resource officer. They also would like to file civil suits against the school district for failing to follow Reggie's IEP. Okay, back to the panelists. So our first question for part 2. In addition to getting arrested, Reggie is expelled from school. Is Reggie able to fight this suspension?
Yes, the answer is yes. When you have an IEP, you are entitled to additional due process. If you are being suspended for more than 10 school days total in the school year, you are entitled to what's called a manifestation determination meeting, where the school sits down with your Iep team and says, is Reggie getting suspended because of issues that relate to his disability? And if so, how do we make his IEP better so that that stops happening? That's supposed to happen when you reach 10 school days of suspension, whether that happens 10 days in a row or whether it's 10 days total in the school year. You're entitled to that meeting. But there's all kinds of due process that would have to happen also if the school made any attempt to expel Reggie. They would have to do a lot more than what they would have to do for a typical student without an IEP.
And Lauren, going off of that, can you explain what course of action a parent should take if they want to fight a suspension or an expulsion?
Can I jump in real quick? I just want to put it out there that anybody can fight a suspension. That there's an appeal process, no matter if you have an IEP or 504. I just want to let parents know that anyone can appeal a suspension at the school level as well as the district level. Just wanted to put that out. I'm sorry.
No, thank you. That was very helpful and informative. So I guess Detective King or Lauren, what action should families take if they want to fight a suspension or expulsion?
So what I've seen is parents should first appeal it with the principal. I think that's the first level of appeal. And if they're unsuccessful there, then they can appeal it to at the district level. Now, outside of that, as far as I'm not sure, maybe Lauren can expound a little further, but you can always appeal it to the principal. And then if you feel unsatisfied, you can appeal it at the district level.
I agree. I think the first thing to check is always to go on your school's website and try to find the code of conduct. Those are usually available and published on the website. And if you search them, they usually lay out like the grievance procedure and the process for appealing if you disagree with disciplinary action that the school is taking. So go to that, look at that. But when in doubt, I think absolutely just go straight to the principal. And as Nicole said earlier, put everything in writing. Be as, pleasant, obviously, as possible. That always is going to get you more, I think, response than the opposite. But laying out your concerns and why you feel that it's not an appropriate suspension. And I always say to parents, end your email with a request for action on the part of the school, or with a question like, what will the school do to address this? What can the school do to assist me with this? When can we meet to discuss this? And emphasize that you want to be collaborative, but that you're asking for action.
I want to also chime in here with a comment that Kyle made in the chat and said, additionally, a lot of families and students who are vocal about their students may not get their voices heard if their experiences aren't packaged or articulated in a certain way. And I raise that now in the context of this conversation is because, there are many parents who are great advocates for their kids, sort of speaking to what my Uncle Ken Swain here is saying about the parent advocates. How do they even know these things? How do they even know who to approach? Some may know to go to principal, some may not. So, perhaps we can maybe go down a line of some resources that parents should tap into when they don't know where to go to. For me, I'm a big advocate of a couple of things. The first is your local elected officials, state people that come ask you for your votes, state representatives, state senators, people who are knocking on your door, your city council people, for a lot of the people who are watching from the city. If you don't know where to go, that's part of what these folks are responsible for, is connecting you with resources. That's part of their duty. So, you might be worrying about, well, I don't know how to pay for a lawyer. I don't know how I'm going to get a lawyer. Even though I would recommend that you do look into law firms like the one that Lauren used to work for to seek a consultation. But certainly local elected officials are good people to go to as an initial low cost, low exertion point to get information if you don't feel comfortable going to the school where you think you might be doing battle with to get fair treatment.
Wally, there are also advocacy groups, and for the life of me, I'm drawing a blank, but I dealt with them when I was sometimes I'm a hearing officer at East Side, where I'm on the board, and we've had I can't think of Devin's last name now.
Hinson.
Yes, and that group, and who would come in and advocate on behalf of students and interacted with at least the principal or the head of schools at Eastside, and indeed helped. And I think Jay Street did it at one point. Whether he's still doing it or not, I don't know. Would come in on behalf of students and press the issue of, had the student been treated fairly? And I think those are also resources.
Yeah, I think the No, Judge Tyler, there was a delay on my end. Go ahead. I thought you had finished. You were talking. Go ahead.
No, it's just that there are, and I agree with you that when I think what I said earlier is that a lot of times people don't know what they don't know and don't know how to approach a system where things seem to be against them. Sometimes it may be, sometimes may not be, but if you don't know, then you need to, I think the idea of going to elected officials is great. I think these advocacy groups do exist. I know because having dealt with them in the context of advocating on behalf of students, that they need to be able to package, just like Lauren said. You can fight, but there are rules of engagement, and I think that a lot of times, and I had a situation where a grandfather came in. I just happened to know who the guy was, who was coming in with a mother, his daughter, to raise hell until we showed him the video of the kid knocking out the teacher. That was an easy one, but in the sense that he was sophisticated enough to know how to approach it. Everyone isn't like that, and I've seen people that I felt sorry for who didn't have the faintest idea, who may have had some arguable right. And I think the way to approach it is the way they said, but we need to do more. I do agree we need to do more to provide advocacy for kids where the parents may or may not be correct, but the kid may or may not have been treated unfairly, and someone needs to look at it. So any public official, and I think, and the lawyers would have to tell me, but I thought you're entitled to attorney's fees if you're able to prove that there's been unfair treatment in that realm. Because I remember I got threatened by a couple of public advocates who said they were going to get their attorney's fees paid, and I said, "What do you want me to do?" But so I agree, and I think we have an obligation to do more. And I agree with Detective King. You fight for your kid now, do the best you can, but it helps to have it packaged in a manner which makes it more palatable to the school officials.
I completely agree, Your Honor. And I wanted to highlight, so you mentioned Devin Hinson. He is an excellent advocate and a friend, and he runs an organization, and he may not be officially affiliated with this organization anymore. It was called Education Voices, but I know he is still fighting the good fight and assisting parents in resolving disputes with their schools. So he's a great resource. Parent Information Center is the one that I had mentioned earlier. That's PIC for short, PIC. Their website is picofdel.org. They are actually like a government-funded entity, and their job is to provide parents with answers about what their rights are. They do parent trainings. They actually have advocates that you can call that will review the child's IEP and talk to you about it or help you understand the IEP process. They offer all kinds of different services, and they have a website with all different information. So I would urge families to check that out. Again, PIC, picofdel.org, Parent Information Center. And then the Department of Education's website, Delaware DOE's website, has a lot of information about what your rights are and what parents can do and who they can reach out to if you want to escalate the issue above your local school to the district level or up even to the actual DOE level above them. And charter schools are obligated under these laws too. So they are, just as, a part of this process as any other public school in Delaware. So if you're having issues with them as well, you can escalate that to the local school district or to the DOE for assistance. And then I wanted to also highlight what you said about the funding issue. You are right about that. IDEA, there is a fee shifting provision in it. And that means that if you are successful and you prevail in a claim that your rights were violated for your child's IEP, the school district or whatever public school agency you are suing has to pay your attorney's fees. So when I was practicing in my private firm, I only ever had one client in all of my 7.5 years there who paid me out of their own pocket. Every other client, I got paid by the school district when we resolved their case. But that meant that I could only take cases that were meritorious. So, if you think you have a case, absolutely consult with an attorney and don't worry about, oh my gosh, am I going to be able to afford private attorney's fees? Most attorneys that practice in that area will review the case and let you know if they think it's a case worth pursuing. And, ability to pay is usually not a barrier to them being able to take the case.
I would suggest that all lawyers should only take cases they think are meritorious, but who am I?
Just to put a cap on that, I think the key part about this conversation is that there are multiple areas where you can get support when you are trying to determine what your rights are and evaluate issues that you may think if something just doesn't feel right. They are out there. The question is how do you find out about it? And we've highlighted again a few, online resources, entities, organizations. Even note that the organization that is hosting this program, One Village Alliance, provides those advocacy services very effectively on behalf of students in schools to, again, get to the heart of the issue, because the issue is about making sure that the kids get what they need to make sure that they have an appropriate education is what the law requires, but really is to maximize their educational experience, I think, for these kids. So shout out to One Village Alliance for the work that they do. Paige, did you have, do we have more questions?
I do.
Okay.
It's been great. Okay, so this question is for everyone. And I'm going to preface it as for Lauren and Nicole, I would like you guys to answer the question as if you were defense attorney and prosecutor. Detective King, if you can think about this question in your role as an SRO and how you would approach the situation. And Judge Tolliver, think back to the days when you're back on the bench and this is a criminal trial before you. So how, if at all, does Reggie's mental diagnoses and IEP play into the analysis of his criminal charges? And I'll start with defense and prosecutor first.
I'm going to go first as the prosecution. I've been itching to answer this question. They play a huge role. So what Reggie has going on here is what we would call mitigating factors, right? Information or background story about a person, about an alleged offender that gives you a better understanding of their whole story and what may cause them or what may influence their behavior or decision making in some way. And so Reggie being a student with an IEP, he has several diagnoses here. As a prosecutor, I'm looking at that and I'm questioning what the process was in making that arrest and why him, and was this information that was known. I'm also looking at Reggie's age. He's 15 years old. There's a lot that if this case came to my desk, I would be reluctant to move forward with criminal charges on it, given the situation, and also knowing about obligations with a student with an IEP.
I agree with everything Nicole said. This is absolutely mitigating information that would be very relevant for us to know as the defense attorney in this case, especially the fact that he is a child with an IEP. I have had cases like this in my criminal defense practice. And when I see that the issue that led to the child being charged came from the IEP not being implemented, I've been successful in getting those cases just completely dropped.
Detective King.
So for me, in this situation, I really wouldn't know if he had an IEP or not unless, the child explained that to me. Because, as school officials, they're not just going to say, hey, hold on, he has an IEP. But with that being said, for reading the fact pattern, I don't see where he necessarily committed a crime. He might have violated school policy. He's being a disturbance. But once he's in the hallway, then, and if he wants to walk around, then the school discipline side of that, then that's the school discipline side. I would have no, I wouldn't put my hands on that at all. And now, as far as the broken door, just reading over the fact pattern again, you know, the I don't want to sound like a lawyer, but I think the law protects certain properties, you know, private property, stuff like that. And for the school in a situation like that, where, you know, there was no one hurt in the situation. So I would not arrest him under this fact pattern. I would try to talk to him, but I would not arrest him at all.
So just a quick follow-up on that with you. Laura and I, like I said, Lauren and I both work at the public defender's office, and we represent juveniles. And this is kind of something that we see often, frequently, situations and scenarios similar to that. I understand that you wouldn't know a kid if a student had an IEP, but since you said that you had a good rapport with a lot of your students, if either in the school setting or even on the street, if you're aware that a subject or a student has mental health concerns or even might be in a crisis situation, do you approach that person differently that you know is suffering from mental health illness versus just another student or just someone else on the street?
Speaking quite frankly, yes, I would. That plays a huge factor. Matter of fact, last month, there was a kid who he pretty much ran at me and challenged me physically. But I knew he had issues. And, you know, his mother called the school the next day and thanked me for not harming her child. But, you know, I can honestly say he probably would have been arrested had I not known that he had these issues. So those things always play a huge factor, especially in the kid. And sometimes I might know, just to clarify, I might know somebody has an IEP if I've dealt with the individual before. So for instance, and I think Lauren, you can probably clarify this, because some schools operate differently. So if Reggie got into a fight with Johnny, and they both mutual combatants, and they both receive school discipline, I've seen where administrators might say, well, he has an IEP, and they're scared to get to that 10 days. So they'll say, okay, we're only going to give him 2 days because he has an IEP, but, you know, go ahead, hit him with the 5 days because he doesn't have an IEP.
Thank you. And Judge Tolliver, sitting on the bench, once you're aware of a defendant that has an IEP or has mental health, and that played, at least on the defense's side, that played some role in the charges, how do you analyze that, either in sentencing or finding guilt, if relevant at all?
Well, let me go back a little bit. I used to do the reverse amenability hearings. I don't know whether they still have them or not. It's been 7 years to determine whether a kid is held as an adult, tried as an adult, and be subject to family court. But in this case, I think I would approach it a little differently. Once you knew the kid had some problems, first of all, I wouldn't have charged him with a criminal offense. I would have had I been the SRO, to physically restrain him, because what you don't want is a kid who's very upset and demonstratively physical to go hurt someone else. So you have to protect the other students. Now, having said that, whether I wouldn't have expelled him, because I'm not sure what the expulsion basis would be. Now, whether he should be suspended or not, I can't say. But given the situation, given the teacher involved from the fact pattern, given the difficulty of the situation, I think I would have indicated to the state and the defense, we're going to handle this another way. And I don't know if how, but I think I would have conveyed to the state don't charge him criminally. The school should not have charged him, and we'll just have them deal with it administratively. And if he comes back again under a situation in a set of circumstances that cannot be explained or cannot be justified, then there's going to be a serious problem. But I would not have, under the facts of this case, no, I would not have. And I've seen some juveniles who are really bad, committed or at least accused of committing homicides. This kid is just somebody who's has issues. Now, whether I would have put him in that class under those circumstances is a function of the IEP, and whether I should have taken him out, put him in a separate school environment, I don't know. But under these circumstances, I would not charge him. I would not expel him. Whether I suspend him or not for a couple of days, it depends whether he had a past history, whether there had been some difficulty. But given this teacher's makeup, I wouldn't have put him in there because the teacher was right to conduct this class. But on the other hand, am I wrong? And the fact situation may be a bit much. If a kid's tugging on his ear so he can go sit down, I mean, I'm not so sure I'm going to be paying a lot of attention to that, particularly if I have a predisposition not to care about that kind of thing. So wouldn't charge, wouldn't expel, wouldn't. If anything, I think I would go for, and Detective King could tell me, and maybe Lauren could too. Some schools I know we do at Eastside have in-school suspension. I might go as far as to do that for a day or so that he could know what he did was wrong, but at the same time, the way he reacted was wrong, but at the same time, not deprive him of the continued opportunity to get an education, because that's what it's all about.
If I could ask for maybe Detective King to maybe elaborate on a couple of things that I see in the chat that are relevant to the conversation. There was a question which I think was fundamental. You raised a couple of times the fact that it would not be appropriate for you on the front end to be exposed to every student's IEP who had one. And if you could just drill down on that in terms of why some may be surprised by that. They may think in your position in the school, that will be important information to have, but maybe you can clarify why as a policy that's not the case. And then secondly, in the fact pattern, could you highlight wherein there was activity that could have been identified as criminal or could be classified as criminal, where there's a judgment call to be made about making an arrest or not making an arrest?
So the first part, as far as why the known to me, because I'm not a member of the school. I'm not part of the school staff, and that child has a right to privacy. So in any interactions that I would have with the kid, the IEP would not be. I'm gonna use the word relevant. So that's why I necessarily wouldn't know on the front end if he had an IEP. Now, if someone has a severe disability, like Christiana School District, they call it REACH. Colonial, they call it Integration A, where it's, I don't know the legal terms, but like where they're extremely low, like something like that would be brought to my attention. But for the most part, a regular IEP, no, that wouldn't be brought to my attention. And the second part, the only criminal aspect that I would see would be damage to the door. And I would have to determine, in my estimation, that damage was done with intent to damage, or it was very reckless. In this situation, I don't think that it was either one. And also, as far as me, go going hands-on, so to speak. The reason why I wouldn't do that is because once you do that, then there's no turning back from that. He's either going to the hospital or he's going to somewhere out the building. So now I do want to stay in close proximity so he doesn't hurt himself or anyone else, but I'm not going to go hands-on unless I have to. And then once I do go hands-on, then like just because I put handcuffs on somebody, sometimes it's just to take them to the hospital because they're extremely elevated and they need those extreme services. And let me know if I did not answer any question.
I think you hit it right out the park. I didn't want to assume, but to your point about the first question is that the IEP really is about delivering instruction. It's about accessing the curriculum and about accessing the educational experience. So even though you're in that environment, your role is different. So I appreciate the distinction you made about where it's something that's more extreme behavioral, which could potentially invite the opportunity to, when it manifests to break a law, that might be something that be raising your attention. But a child who has an IEP inherently doesn't necessarily invoke concerns of laws being violated.
And I think this brings up a good point too, that just because the school can't share certain information because of FERPA, about the child having an IEP, that doesn't mean that the parent and the child can't make the decision to share that information with the school resource officer if they feel that that would be, beneficial to helping keep that child safe in the school building. I always encourage parents. I know that people feel, sometimes very reluctant to share information about child's medical diagnoses and disabilities, but being an open book and making sure that the adults in that building are armed with the right information to be able to keep your child safe, I think is the best, way to do things. And the school resource officers often have very close relationships with families and with students and can be a great ally in making sure that that child is safe, especially if they really know kind of the backstory and the underlying issues at play.
And also to make another point, sometimes I've determined that, the child is a danger to the building. And so sometimes I will remove them from the building, but that doesn't necessarily mean I have to make an arrest. Because I can just, there's often a joke around the school saying that I'm the state police Uber, because sometimes I'll just run a kid to his parents and, drop him off with his parents, because I know that this could escalate somewhere where, so to protect the child and the school from each other, I'll just take them home.
All right. Our next question, I am going to, I'll leave it open to everyone. But mainly, Miss Madam Prosecutor, does Reggie have a criminal case against Officer Smith?
So Reggie doesn't have a criminal case, but the state will likely have a criminal case against Officer Smith. Now, Reggie would be the victim in that case, but the criminal case is we're looking at Officer Smith and reading the fact pattern. It said maneuver, wasn't quite clear what it was, but seeing the image, I guess you can definitely say there was some type of force used by Officer Smith. And so that's this would be an incident where my office, the Division of Civil Rights and Public Trust, will look to see was the force that was used by Officer Smith justifiable as it's defined under our Delaware law. And when law enforcement officers use force as a defense, I guess you could say, the standard is that the force that is used, that officer reasonably believes that such force is immediately necessary in order to effect an arrest or to contain a situation, whatever may be going on. But that is legally interpreted to be an objective reasonableness standard. So it's going to be based on an objective, reasonable person, officer in that particular situation. Was it legally justified to use force? And in looking at this fact pattern with Reggie, knowing that when the Officer Smith first gets there, Reggie is visibly upset. He's pacing, his fists are balled. He did not necessarily, I don't think, if I remember correctly, did anything to provoke or would cause the officer to use force. And in our view, looking at this, I don't think Officer Smith would satisfy the objective, reasonable standard of force to be able to justify what he did. And so that would lead to criminal charges against Officer Smith.
And going off of that, is there a civil rights case? Does Reggie have a civil rights case potentially against Officer Smith and his?
If I could interject, with all due respect to Madam Prosecutor, first of all, you wouldn't get an indictment. Second of all, you're not going to get a conviction. The best you would get is a hung jury, because you don't know what they told the SRO to run down the hall. The school kid is visibly agitated and trying to leave or run or do whatever he was going to do. And on those facts, no, I don't think you have enough. I mean, I don't know what you're going to charge him with as a crime: assault. Second, there's got to be a physical injury, so you don't have that. In terms of civil rights, again, it depends upon what the officer was told, what he did, and how the child reacted in that set of circumstances. It was a bad day all around, but the SRO really was thrown into a situation not knowing much. And I would tend, it's a matter of opinion, but I tend to disagree. You may get an indictment, because they say you can indict a ham sandwich, but you would not get a conviction. I'd stake 24 years on that one if it survived the motion to dismiss by the court or to the court. Civilly, I don't think you have any injuries, so from the fact pattern, you can't really tell. But this, if there's civil action, it's against the school, and it's nothing criminal in this situation that I would look at. I don't know. That's just an opinion, worth no more or less than anybody else's.
Well, thank you, Your Honor, for sharing that perspective. Again, referring to the fact pattern, there was a fact that Reggie did suffer physical bruising from the force that Officer Smith used. And so that would be considered in issuing the... Yes, and our office would still be inclined to at least pursue an indictment and see, you know, if this case does go to a trial, we obviously would put our best foot forward, and we want to charge cases that we feel very strongly about being able to satisfy the burden for a charge. But it would be sufficient under our perspective in interpreting use of force cases to charge Officer Smith here.
With a misdemeanor?
Yes, Your Honor.
I must have missed that one in my 24. But okay.
Well, the past couple of, we've been charging misdemeanor offenses for other official misconduct cases, other cases involving law enforcement officers. A crime is a crime, whether it's a misdemeanor or a felony. And the Division of Civil Rights and Public Trust, we are tasked with looking specifically at law enforcement officers' use of force.
I have a question along those lines now. As an SRO, one thing that we're tasked to do is not to allow somebody to cause, if I'm trying to articulate it the right way, is a disturbance to the educational process. So where does your office sit on that? Because if Reggie escalates to a point where nobody's learning, then you do have disorderly conduct there, and then arrest would be warranted, would it not?
Are you talking about an arrest of Reggie at that point?
Yes, ma'am.
So it may be warranted, but then that would take us back to our previous question about, well, what does Reggie have going on? The disturbance that was created, was that a result of the mental diagnoses that he has? That would take other considerations if the fact pattern went down that road.
And I think it's important to highlight in this conversation that there are really two things going on. There's the layer of law enforcement and the arrests, and then there's the layer of sort of administrative repercussions that can be doled out. And I'm speaking in the context of Reggie's behavior. And this is top of mind for me, as I mentioned at the introduction phase of this dynamic discussion we're having. I sit on the State Board of Education, and there was a comment earlier about the appeals process and the layers of appeals, and you could take something to the principal and the district. Well, a lot of people don't know that for certain, particularly with expulsions, you can, and I think even suspensions, you can take that all the way up to the state board. And we heard a case where there was a decision that was made at the school level about, I won't get into all of the particular facts, but it involved some level of dangerous materials that were on the student's person. And the question was whether or not he intended to use them for some nefarious purpose. And the arresting officer decided that was the case. However, ultimately, the student wasn't charged with a crime. Now, the school still decided to expel this student for that reason, but he was not charged with the crime. So it went to the district level, and then it went above, and it went all the way to state board. Ultimately, for the surrounding circumstances, my colleagues and I decided that it was a punitive, that the school was acting in the capacity as a punitive body, as opposed to a body that was interested in maintaining the safety of the educational environment for all the students. They were essentially acting as a de facto law enforcement arm by holding this expulsion, when they didn't really think about, was that, to use a term that Lauren introduced to us earlier, sort of this least restrictive environment for this kid. Did he really need to be expelled? They still had an independent obligation to provide education for this student. So I find it interesting, that tension between what is on the law enforcement side of these conversations when you have these outbursts, and what's on the school side. And they might seem like they're the same thing, but they're different.
If I could add this, and I want to make sure my comments are not misunderstood. If you're talking about that, because if the officer had not restrained him, maybe he shouldn't have not put his hands on him, I don't know. But if he had not, and that kid had hurt somebody else, I can guarantee you there would be a suit against the officer and the school district for failing to protect the other students. Now, where the happy medium is, I think Detective King said it best. If he had to get in between them to stop something, that's a different situation. And the misconduct cases that I saw didn't involve an actual assault, and I've not seen one in a school setting. Now, again, been away from it 7 years, but where someone tries to stop someone from doing something, and then you get an indictment for a misdemeanor against someone who was told to do something and may not have done it the best way. I understand the prevailing feeling, but I also understand you're not going to get a conviction unless this guy just clearly disregarded everything in the world, the SRO. I just don't think you're going to get it. And I think the best, SORs are not going to intervene, and somebody's going to get hurt. So, I mean, it depends on how you look at it, but like I said, I must have missed those.
Just to piggyback on what Judge Tolliver said, I wanted to make the point that schools, not just school resource officers, because I'm sure that Delaware State Police go through a ton of training on proper restraint, safe restraint techniques, and the best way to restrain somebody who's in a crisis like this. But school staff also actually are required to go through training on implementing safe restraints. And so that is something that a parent can ask questions about if their child has been restrained, and especially if they've been injured in the school setting. What training did the staff receive, and was the proper restraint technique used in that circumstance? Because that can give rise to liability as well.
This question, it's going to be a two-part question, and Nicole and anyone else can chime in, but I think it's really important. I want everyone to get this information. Nicole, can you speak on whether Officer Smith violated Reggie's civil rights, and when, if at all, can a citizen file suit against a government official?
Sure. So again, looking at the fact pattern with Reggie, we're talking about an interaction between him and Officer Smith. There's some information there that we know Reggie is a student with disabilities. He's a student, he's an African-American student, and there's also some facts about the Officer Smith, I guess, having similar interactions or use of force with other Black and Latinx students. So the things that pop into my head reading that, and the question that's posed, is that there could potentially be some civil suits that arise from this. Reggie civil rights, going back to the IEP, the educational rights that may be available there could be an avenue, as well as if there's, again, this pattern and practice that's going on within the school, it would lead to an investigation. I'm not sure if it's going to lead to an actual suit, but at least an investigation into what is the response, how is the policy in responding to situations like what Reggie experienced, other students that maybe fall within that category of Black and Latinx that have had interactions with Officer Smith. That could be race, it could be color, national origin. Is there some type of disproportionate impact? Is it maybe even a step above that in actual discriminatory intent or bias of some sort, some type of animus towards these bodies of students? Those are things that will all be considered in trying to determine whether there could be a civil suit explored on behalf of Reggie or on behalf of a classification of students that maybe would fall within a pattern or practice. Now, to the second part of that question, Officer Smith, again, focusing specifically on him, would be considered someone who's an actor under color of law, meaning that he's acting within his official authority, or even if he wasn't in his official authority, he's purporting to be. I could say, based on the fact pattern, that he is acting as the school resource officer, so in his authority. And so there are federal statutes, United States Code, I know 1983, could be an avenue for civil rights action against Officer Smith to hold him personally, monetarily liable for the injuries that Reggie suffered here, if there's some way to put a monetary number on that. However, I will say that an affirmative defense to that type of civil lawsuit is what's called qualified immunity. Qualified immunity is what may shield certain public actors from personal liability from any monetary damages in a civil rights action if the act that was taken, the the behavior, the conduct does not violate a clearly established law. And in terms of trying to figure out, well, what is clearly established, is going to be a consideration of, at the time that the conduct happened, was the law sufficiently clear that every reasonable official or actor in that situation understood that what they were doing could be deemed unconstitutional. That is kind of a high burden to, or it's a challenge to overcome more often than not, where a lot of qualified immunity affirmative defenses are successful. And so it's hard to successfully hold a public actor under color of law liable under that. I do want to take a moment to just highlight that right now in the Delaware General Assembly, there is a bill on the floor, which is House Bill 255. It's called the Deprivation of Civil Rights. And that bill would create a criminal avenue. So if, again, a public actor who is acting under the color of law violates or deprives a person of a civil right, whether it be under the U.S. Constitution or under the Delaware law or Delaware Constitution, then it creates a criminal avenue to hold that actor accountable in a different context. So it wouldn't be a civil case, but it would be a criminal case. And so that bill is in the floor. I believe it's passed the House. It's now with the Senate for consideration. It literally mimics, it's modeled after the federal deprivation of civil rights code. So that's something that we may have soon here in Delaware as well.
All right, so I want to open this up now to the audience. If there are any more questions coming through in the chat or comments that you guys want us to speak on, I have received one, and this is from Pat Chapman, so shout out to my mom. And she just wanted to note that it's clear that Reggie has experienced one or more traumatic events in his life. Public and charter schools in Delaware are receiving training on trauma-informed practices. The goal is to look at Reggie through the trauma-informed lens, which involves moving from punitive practices to implementing restorative practices, as well as providing mental health supports and teaching skills to handle intense emotions. So I think that's really important. I know we are on this big move right now with being more trauma-informed in pretty much every aspect of life. And I wanted to highlight in this fact pattern something that we see very regularly in the Office of Defense Services is youth and adults that have pretty severe traumatic histories, mental health histories that have been untreated and undiagnosed. And now they find themselves in a criminal legal system. And a lot of the times it is connected to their mental health needs that have been untreated, trauma that has been unaddressed. So I think that it's very important that we all consider that, not only in the criminal aspect, but just in life, that sometimes when someone is having a bad day, if someone's coming off very nasty, they're dealing with a lot. Everyone is dealing with a lot. So, but I open this up. If panelists, if you guys have any more questions, audience, if you have questions or comments, please let us know.
I just wanted to note two resources that I forgot to mention earlier. The ACLU of Delaware does pursue some education-related cases. And then Classy Community Legal Aid Society Incorporated is a nonprofit legal agency in Delaware, and they do also take education cases as well. So parents can also contact them if they're concerned about their child's education rights being violated.
I'll say if there were any other questions in the chat that you previously made that were not addressed, then please restate your question as we're heading into sort of the back end of the discussion. So again, we want to make sure that while you have a captive audience of talented lawyers and a sitting and a former and a recently retired sitting judge, we want to make sure that you take advantage of this audience while you have it. So Paige, are you seeing any other activity in the chat? I see that One Village Alliance dropped the website for Classy, as Lauren just mentioned.
There is an earlier question from Ken, and if we've already addressed this, please let me know. But how does a parent know that these options are available for appeals or due process? I think this was related to suspensions and expulsions for youth. Will anyone in the school proactively speak up and inform parents of their rights and options when incidences arise?
So for the Colonial School District, as well as the Christiana Schools District, when a child is suspended, they have to sign a suspension form. And these things are on the suspension form. And Colonial actually goes through, they go what I would consider the extra mile, where they actually, it almost sounds like they're Mirandizing a student, where they're informing them, do you understand that you have a right to appeal? And this is the appeal process, and things like that.
All right, looks like we have from Chuck. I have to thank God that both of my parents were teachers and understood the educational system and navigating these waters like skilled sailors. I'm interested in knowing what efforts are made to eliminate on a systemic level this sort of racism.
Chuck, can you clarify what you mean by that? I'm not sure I understand the reference back to, it might have been in the flow of a conversation we were having when you made that original comment. Or if someone knows the context, you can chime in. I think that was a question that probably came in the flow of a discussion.
I would just say systemically, ACLU and Classy both really try to focus their litigation on big picture issues and issues that make impact on a huge group. So they're the ones that try to fight when they see these things happening systemically and affecting, an entire group of students. So I know the ACLU in Delaware did participate in a national suit, I believe, involving the disparate impact on Black and Brown students with disabilities and being under-identified and under-evaluated and underserved when they should have absolutely had appropriate IEPs and appropriate services. And instead we're being treated like, you're just a disruption, you're just a bad kid. And a lot of that seemed to be very motivated by just the color of their skin. So ACLU does a lot of great work with that.
And I would also add that the U.S. Department of Education, several years back, and how long, 4 or 5 years, investigated the discipline of students in, I think it was the districts in Newcastle County. And what the outcome of that was, I do not know, but I know the investigating officer, because he was my brother, was an attorney for the Department of Education. And he interviewed a number of people, including Mr. Patton, who was then principal at Bayard, I believe, and some others. And that was, they looked at it. Now, what they came to, I do not know. But I do know that they received complaints and at least did come to investigate. Again, I do not know what the outcome was because I just plain didn't know.
Right, and we have a question from Armani. Wouldn't it be helpful for schools to teach young people how to deal with police? Saying one wrong thing can change your life forever. I'm just going to answer this quickly, and then the rest of the panel can talk. But I just want to throw in a plug. Myself and some of my other colleagues from the Public Defender's Office, we take our show on the road, and we do a Know Your Rights campaign where we stop at schools. So, for example, I will be speaking at Christiana Newark High School tomorrow, and Bayard School, or Bancroft, on Friday, where we speak to youth about knowing your rights, about how to interact with police, how to properly or appropriately and respectfully assert your rights when being approached by law enforcement or being investigated. So if your school is not doing anything you're interested, our office does. And so we are more than happy to talk, and we actually love talking about your rights.
I'll also put in a plug for organization Detective King. I think you're affiliated with Noble.
Yes, I am.
Okay.
Yes, sir.
So
Yes, I am, sir.
I'll put in a plug for Noble, and they have a program called Learn to Live. And it's a program that talks about the very similar concepts that Attorney Chapman has just mentioned, where they're educating youth on the mock scenarios like we're going through now, right? The best way to learn is to simulate and experience, so that when it actually comes up, it won't be your first time. You have some muscle memory, and you can say, you know what, I remember hearing what Attorney Mahler said to me, or Attorney Mozee said to me about this, or what Detective King said to me about that. And there are other programs. I led a program for years called The Achievers, where it's a 6-month workshop series. And one of the workshops that we had was a workshop that was specifically based on learning how to navigate different scenarios you may find yourself in when you're interacting with law enforcement. On the specific point about why schools aren't doing more of it, I think we can ask that question about schools in a number of ways. Why aren't schools teaching about financial literacy? Why aren't schools, preparing you more for how to manage, your household? There's certainly a limit in terms of what schools can and should do, whether or not that's right or wrong. I think we don't have enough time to debate that. But what I will say is that there are resources out there to help bridge the gap, as we've identified a few of them. And hopefully, that will help to the extent there's interest in pursuing some of those organizations for the great programs they do.
I know Noble, in addition to what you're saying, I know Joe Bryan, a frat brother of ours, was involved with another program and DuPont is their minority employees group was involved in that as well. That's currently ongoing, and it is critical because I've seen situations where things get out of hand, and how you interact with the police is not a simple situation, but we need to educate our kids more in that regard. And I would very much encourage that to be a function.
Absolutely. So I think that we have hit our time. I don't see any flashing red lights from the comment section telling us that there are a bunch of questions that inquiring minds want to know. So I'm just going to take this opportunity to express my sincere gratitude for each and every one of the panelists here who have assembled, who've offered their time and their knowledge for the benefit of the broader community that's been assembled virtually throughout the world, who's tuning in to learn about how they can be more informed in this space. And I also want to just definitely shout out One Village Alliance, the Raising Kings organization, for their leadership in terms of shepherding these discussions so that they can be made available in the public discourse for the benefit of all of us as a community. So with that said, thank you all. This was an incredible discussion, and special shout outs to Paige Chapman, who expertly navigated us through this experience. And we thank you all very much, and we hope everyone has a wonderful evening. And please stay tuned for the next round of Raising Kings programming. Again, this is a year-long model of programming that's going to be helpful and positive and contributory to us. So have a great night, everyone. Stay safe and be well.